Afternoon, and welcome to our April installment of our webinar series. I'm Jackie Baxley, and I'll be leading you through our webinar today. Our webinar topic today is a regulatory update, so we'll share with you some information about some rules and regulations that are changing and how they might impact your operations. A little bit of administrative details before we hop into the webinar. All attendees are in listen-only mode, so if you have a question, we'll encourage you to either use the chat or the Q&A function of the Teams webinar platform. And we'll make sure to answer those questions at the end of the webinar. Also, at the end of the webinar, you'll have my contact information. If you have any questions that you just don't feel like typing into the question toolbar, feel free to reach out to me directly, and we can talk through your questions and the nuances. Copies of these slides will be made available after the webinar. So you can expect to receive an email with a copy of these slides following our live broadcast. All right, so with those administrative details out of the way, thank you for joining HRP's webinar today. Since 1982, HRP has worked with our clients to ensure that they move their environment forward. And what we mean by that is we work to minimize the environmental and compliance risk associated with our clients' projects and help them reach their business goals. We're a multidisciplinary environmental compliance and engineering consulting firm with several offices across the country. As compliance consultants, obviously, we have to stay on top of changing regulations so that we can better serve you, our stakeholders, and our clients. So with this webinar, we will be sharing with you those regulatory changes that we're keeping an eye on and also highlight what those changes might mean for your operations. I'll be leading us through the webinar today. My name is Jackie Baxley, and I am the practice leader for HRP's Environmental Health and Safety and Sustainability practice. I've been working in the arena of environmental health and safety for over 25 years. About the first third of my career, I was in manufacturing. I worked in the textile industry, and then I worked in the chemical industry as an environmental engineer in both of those locations. And the last 2/3 of my career has been in the consulting arm of environmental health and safety, consultation and compliance. So what we're going to cover today in our webinar is first we're going to highlight some of the environmental regulations we are watching. Then we're going to jump into some of the health and safety regulations. And then we have a few honorable mentions to share at the end as well. Now, our focus today is just going to be on the federal regulations, though there's always movement at the state level as well. So whether you're sitting in Connecticut and you're dealing with the new stormwater general permits, or maybe you're sitting in South Carolina and the legislature is considering new regulations about siting and expanding manufacturing operations around schools. Or maybe you're sitting in New York and there's new greenhouse gas reporting rules in New York. There's always movement at the state level as well. But in this webinar, we're going to be focusing on the federal regulations that have a broad appeal across the different folks that might be participating in this live webinar or listening to the recording. So if you have any questions about anything state specific, again, my contact information will be at the end of the webinar. We'll be happy to talk about any of those state-specific regulatory changes that you might be interested in. All right, so let's go into what are the environmental regulations we are watching. Well, I don't think it's possible to have a regulatory conversation and PFAS not come up at some point in time. So let's go ahead and start right off with a PFAS rule that we are looking at. So under the Toxic Substance Control Act, also known as TSCA, there is a rule that was passed in 2023 relative to reporting and record keeping for PFAS. PFAS, if you're not familiar with, are per and polyfluoral substances. So this final rule was first published toward the end of 2023. It required those that manufacture, including import, PFAS or PFAS-containing articles in any year since 2011 to electronically report information regarding those PFAS, their use, their production volumes, the disposal, exposures, hazards, and a myriad of other information. So why this rule mattered? Well, it did not include the traditional exclusions that TSCA rules typically had, which resulted in widespread applicability. It resulted in folks that normally don't have to worry about TSCA all of a sudden having to worry about TSCA. Plus, it had this significant look back burden. We were having to look back at an operational period of January 1, 2011 through 2022. So I just noticed a typo there. That should be January 1, 2011 through December 31 of 2022. So 11-year look back period. That's quite sizable. And so this rule had no exceptions based off of company size, no exceptions based off of the concentration of PFAS in an article, no exceptions based off of the total amount of PFAS imported or manufactured. So this was quite a regulatory burden for our regulated community. Now, to learn more about this rule, we did a webinar last year on this rule that gives a little bit more detail of to who it applies to and what is the obligation and what needs to be collected and reported. And that historical webinar is available on our webinar archives. And at the end of this webinar, I'll show you how to access our webinar archives. So please feel free to go back into our archives and learn a little bit more about this rule if you're not familiar with this rule. Now, if you are familiar with this rule, and if this is a rule that you are also tracking, then you probably know that already the start date for these reports and the due date for these reports keep getting pushed. Initially, back in September 2024, the due dates were pushed, and then back in May of 2025, they pushed those dates again. Well, we've seen some more recent movement as well. So I'm going to start first with April of this year. So these due dates have again been pushed. So the reporting period for that 11-year look back was supposed to open this April. But just about 2 weeks ago, they pushed that due date again. So now the window for reporting under this rule will open January 1 of 2027, or 60 days following the effective date of a forthcoming final rule. So that's going to have me jump back up to that November 2025 action. So if you're a subscriber to HRP's PFAS Pulse, which is our complimentary subscription on all things PFAS, you may remember that back in November, we shared that the EPA proposed a rule change relative to this rule. And so what's important for us to recognize is a proposed rule change is just that. It's proposed. It's not final. So we can't follow proposed rule changes, but it gives us a glimpse of maybe what's to come. So in the proposed rule change in November, it was proposed to change this rule to now allow exceptions. This is a great relief for a lot of the regulated community, as if this rule is finalized as this April 2026 extension kind of nods toward. If this November 2025 rule is finalized, then now all of a sudden those folks that were subject to this rule only because they imported articles, or those that were subject to this rule, but it was PFAS in such small amounts, then there are now some exclusions that may be able to benefit you and may actually get you out of the regulatory burden of this rule. So again, this April 2026 push start date gave a nod that they are anticipating, they being EPA, is expecting this final rule to be published based off of those November 2025 proposed rule change prior to January 31st of 2027. So this is one that we will continue to watch. This is one we'll continue to keep you in the loop on, but our recommendation in the meantime, if you're only impacted by this rule because you import articles that might contain PFAS, or you manufacture or import PFAS in mixtures at very low concentrations, less than 0.1%. So if these proposed exclusions or exemptions proposed back in November will get you out of this regulatory burden, then we recommend go ahead and just pause. Put a pause on your work thus far, because it looks like some regulatory relief is coming your way by January. And then, but if these rules are going to apply to you, regardless of these exemptions or not, continue compiling the information for the report. Again, it's a huge regulatory burden. It's a huge look back period of 11 years. It's a lot of information to compile. So take the gift of time right now and continue to compile information so that when the reporting platform opens up, you've got all the information that you need and you're ready to go. And again, for more details on this reg, please refer back to our webinar archives where we get a lot more detail on what all this regulation entails. All right, so moving right along, the next regulatory program that we're keeping an eye on also is under the Toxic Substance Control Act. And in this rule that we're talking about, it's actually 3 rules, but we're going to talk about these 3 rules together because they're kind of cousin rules, if you will, or sister rules. These rules regarding risk management for methylene chloride, PCE, and TCE were all finalized in 2024. And each of these rules, to some degree, shape, or form, included phasing out and or outright bans in the case of TCE of these chemicals. For now, some of these had specific authorized uses. So for methylene chloride and for PCE, there were a handful of uses that the regulated community could continue to use these chemicals, but there were very strict workplace protections in place for you to be able to continue to use these. TCE, there were some authorized use with some long periods of time with an eventual ban across all categories. But again, for a while you were using them in those authorized use, very strict workplace protections. And kind of why this matters is those conditions for continued use are stricter even than what we saw with OSHA. So we were seeing folks that might be complying with methylene chloride rule under OSHA, but we're not complying with this TSCA risk management rule regarding methylene chloride because it was stricter than the OSHA rule. So more about each of these rules, again, I'll refer you to our webinar archives as we did a webinar last year as these rules were finalized and coming into effect. So now what's changed? So essentially what's changed is just due dates keep getting pushed. So we're seeing that across each of these individual rules. For the methylene chloride rule, one of the authorized continued uses for methylene chloride was methylene chloride use in laboratory operations. And in the way the rule was originally written and finalized, there was one timeline for federally owned and operated labs, and there was another timeline for non-federally owned and operated labs. So back in November of last year, what EPA did is they aligned those due dates. So if you operate a laboratory and you use methylene chloride, and you intend to continue to use methylene chloride as authorized in a laboratory setting, your compliance due date has been pushed out a little bit, and it essentially aligns with what the due dates were for those federally owned and operated laboratories. So this rule change gives you the gift of time. Now, with this particular one, it's really important to realize that this is only for the authorized use of laboratories. For example, there's timelines for authorized use for corrosion-sensitive components of aircraft and spacecraft. Those due dates and timelines are unchanged. It's only for laboratories that have the benefit of additional time now. PCE, similarly. So with the risk management rules regarding for PCE, in July of last year, so almost a whole year ago now, EPA issued a 30-day public comment window to reconsider and, if appropriate, revise this rule associated with PCE. I haven't seen any movement on that since. So I haven't seen any chatter or any predictions on what's going to come out of that public comment period. But there was that public comment period, and EPA was looking to see, does this rule need some modifications, if you will. So that's something we're still watching. No action on that part, but something we are watching. But here more recently, excuse me, that says March 2025. I'm noticing I got all the numbers mixed up on this one. So March 2026, just last month, EPA proposed extending deadlines to align non-federal entity deadlines to match those of federal entities. So similar to the methylene chloride rule, where you had one timeline for federal facilities, one timeline for non-federal facilities relative to labs, the PCE rule was organized similarly. So with this proposed, again, so it's not finalized, proposed rule change, it is extending deadlines to align the non-federal entities with the same deadlines as those for federal entities. So again, this is proposed. What that means is it's not final, which means that technically on the books, the initial monitoring periods are what still stand. So PCE, it's important to note, while the proposed extending compliance date is at that proposed level, current deadlines remain effective until they're modified through the final rule-making process. So what we recommend in this interim time period is still to make progress in complying with this rule. Because if anything, you're just going to have the gift of time. You're still going to need to protect your employees and protect your operations. So continue to make marked progress toward these. And then the TCE rule. The TCE rule has really been bogged down in the courts. There's been numerous stays from the judicial. There's been postponements from EPA. So the path is a little less certain relative to the TCE rule. Most recently, they postponed the effective date until February of this year. And as you read the rule, it will say 180 days from the effective date or 270 days from the effective date. So again, this one just keeps getting pushed down the field. And that's mainly because there has been some judicial proceedings associated with this rule, so its future is uncertain. So I expect that there'll be additional postponements here just as this kind of makes its way through the courts. But again, regardless of whether it's methylene chloride, PCE, or TCE, these are regulated because of the health and environmental hazards these chemicals pose. So if you are using any of these in any of the authorized uses, make sure you conduct your employee monitoring. Make sure you compare that employee monitoring to these much tighter exposure limits that are in these rules. And when I say much tighter than OSHA's. Make sure that you compare those monitoring results to the limits that are in these rules. Protect your employees with exposure controls, whether you're going to need respirators, whether you're going to need better ventilation, whether you're going to need additional work practices. And all of these rules require written workplace practices. So make sure you go ahead and make marked progress in these. Because with this one, it's important to remember the intent here is employee and environmental protection. So even if we get the gift of time here, there's still a hazard that has been identified and just needs to be mitigated. And again, for more information on these rules, more information about these, the employee monitoring, the exposure controls, the written workplace practice plans, refer to our webinar archive. And again, at the end of the webinar, I'll tell you how to access those webinar archives. The next rule is under the Emergency Planning and Community Right to Know Act, and specifically the toxic release inventory reporting that's under EPCRA. So initially part of the 2020 National Defense Authorization Act, that National Defense Authorization Act, which is kind of a weird place for EPCRA rules to be impacted, but in that 2020 Act, The act immediately added certain PFAS to the list of chemicals that are covered by TRI reporting. And it also provided the framework for adding additional PFAS on an annual basis. So since 2020, we're seeing new PFAS chemicals get added to this TRI reporting platform. So why is this important? Why does it matter? Well, we must continually assess and reassess for PFAS chemicals in our TRI reporting applicability, especially after some regulatory movement that impacted our reports last year, which designated PFAS as what we call a chemical of special concern. And what that means is that there's no de minimis amount when it comes to PFAS in TRI reporting. So if you have one of these listed PFAS in a chemical or product that you're manufacturing, processing, or otherwise using, and if that PFAS is in that chemical or product at 0.00032%, it's still fair game relative to evaluating if you need to report it under TRI because it's this chemical of special concern and there's no de minimis. So again, more about this one. This was a topic that we were watching last year as well. Because of that designation of PFAS as a chemical of special concern, we had a very detailed webinar last year on what that means. The webinar got into what is TRI reporting. So kind of high level introduce you to TRI reporting, high level introduce you to PFAS, and then it talked about what these chemicals of special concerns mean relative to PFAS reporting. So that's a good refresher that can kind of tie this most recent rule change. And this most recent rule change for 2026 is that as a result of that 2020 National Defense Authorization Act, remember it had that framework for continually adding PFAS chemicals each year. EPA added one new chemical that will be reportable for the 2026 TRI reporting year. And those are the reports that will be due in 2027. So with TRI reporting, the report is always due July 1 of the year following. So the 2026 report year, that TRI report will be due July 1 of 2027. So the TRI report that is due this July 1 of 2026 is for your 2025 reporting year. So we had one new chemical that's going to be fair game for this year's report that will be due next year. But a good reminder that those of you that are working on your TRI reports right now for the 2025 reporting year, which is due this July, recall that 9 additional PFAS were added to the list for this year's report and moving forward. And so, since the 2020 National Defense Authorization Act, now there are over 200 PFAS chemicals that have been added to that TRI list. And remember, PFAS have no de minimis for TRI reporting. So even if one of these over 200 listed PFAS are in a product or chemical that you're manufacturing, processing, or otherwise using, regardless of how much of it is in one of those products or chemicals, you need to account for its manufacturing, you need to account for its processing, you need to account for its otherwise use within your operations, compare it to the 100-pound threshold, and if you're below 100 pounds, keep a record of such to prove you didn't have to report it. If it's above 100 pounds, then you need to file the TRI report for that PFAS chemical. And each year, you need to assess for additional PFAS chemicals. Remember, each year we're going to have added chemicals. For the 2026 reporting year, it was just one added chemical. For the 2025 reporting year, 9 added chemicals. So it's don't fall into the trap of same as last year, because with these additional PFAS being added, really needs to keep us on our toes. We can't default to the same information and the same evaluation from previous years because just our knowledge of PFAS continues to emerge. Our knowledge of PFAS and products and chemicals we're using continues to emerge, and we continue to add additional PFAS subject to this rule. So do your due diligence each year in assessing your applicability associated with this rule. All right. So these next 2 rules that I want to share with you on environmental, and then we'll get to the health and safety topics. These are proposed rules. And again, in the the process of rulemaking. Proposed is just that. It's not a final rule, so it doesn't require any action of you unless you want to post a comment about the rule. So this proposed rule is going to impact those organizations that are subject to the Risk Management Plan program under the Clean Air Act. And this rule that was proposed just in February of this year, is essentially walking back some of the updates that we saw to the risk management program that were published in March of 2024. So in March of 2024, EPA passed the Safer Communities by Chemical Accident Prevention rule, and that added additional requirements to those subject to RMP. So what this proposed rule change says is that they are proposing to rescind or modify most of those accident prevention program changes that were promulgated by that March 2024 Safer Communities by Chemical Accident Prevention rule. So walking back a lot of those. Also is proposing to rescind most of the public information availability provisions of the RMP Safer Communities by Chemical Accident Prevention rule, and providing limited RMP information through the RMP data tool to satisfy both the community emergency response needs as well as security concerns. And then also it's proposing to clarify some of the community and emergency responder notification responsibilities. So again, this one is walking back a lot of what we saw from that last rule change. Comment periods end in a couple of weeks, May 11th. So if this is a rule that applies to you and you want to make a comment on this proposed rule, that comment period is open until May 11th. And I will be sending out these handouts. I'm going to make those 2 date corrections that I just saw earlier. I'll be sending out these slides after this webinar, so you'll be able to click on each of these links. You don't have to try to type this in to get more information about this particular rule change if it applies to you. This next one, once passed, is going to have wide applicability because it has to do with hazardous waste manifest. And whether you're a frequent disposer of hazardous waste or an infrequent disposer of hazardous waste, when you're disposing of hazardous waste, you are likely using a hazardous waste manifest. And several years ago, EPA had actions and rule changes about the e-manifest, and this e-manifest process has just been kind of a phased approach over numerous years. And so this is just kind of the next phase, if you will, of the e-manifest. And what was proposed last month is that is this paper manifest sunset rule. Again, just in the proposed phases right now. But under this proposal, EPA is proposing to establish a date for sunsetting the use of paper manifest. So that date has not been set yet. This is just saying that they're going to establish a date after which we're not going to have the paper manifest anymore. It's going to be electronic manifest. That eventual date would be 2 years after the final published date. So again, this is a proposed, right? So at some point there'll be proposed, there'll be a comment period, there'll eventually be a final rule change. So when that final rule change occurs, that final published date, then 2 years after that would be when the paper manifest sunset. And all facilities are going to be subject to this rule. And what we mean by that is hazardous waste generators are going to be subject, hazardous waste transporters are going to be subject, and treatment, storage, and disposal facilities are going to be subject. So if you don't already have an account in the RCRA Info e-manifest system, this will be requiring you to get one of those accounts. And that's going to be where we're going to manage those e-manifests. The comment period for this rule ends next week, and more information is provided on the link there that you see on the screen, which is a very ugly link, which is why I'm going to be sending you these slides so you can easily click on these. Now, just a little side note on this one. A hazardous waste manifest is a dual purpose document. it meets some environmental obligations relative to the shipping of hazardous waste. And it also serves as the DOT shipping paper, Department of Transportation shipping paper. So DOT has not yet authorized e-shipping papers. So this is one that there's going to need to be a little bit of cross agency collaboration. DOT is actively exploring and in limited cases allowing electronic shipping paper alternatives. Currently, it's permitted in rail transport, but not yet highway transport. So as we are watching this one, we're also going to be watching DOT because that manifests as both an environmental record as well as a DOT record. So one that we're watching and one that will keep you guys, our stakeholders, in the loop on as well as details emerge. All right, so that takes us to the health and safety programs that we're watching. Not as much final movement on the health and safety rules, on the environmental rules. I think if I was to sum up those environmental rule changes, a lot of them are the gift of time in some of the cases. And in some cases, just the other kind of summary would be stay on your toes when it comes to PFAS. With health and safety, we see a lot of proposed, not a lot of final movement yet, but we wanted to share with you those that are proposed that we're watching. But the first one is one that is a final action. So back in 2024, so a couple of years ago now, OSHA updated the hazard communication standard, and that final rule change took effect about midway through 2024. Now, this rule change mostly impacted those that are required to prepare safety data sheets and labeling, as the rule primarily just aligned the OSHA hazard communication standard with a more recent version of the globally harmonized system for hazard communication. So again, as we're looking at our regulated community, this really impacted the importers, the manufacturers, the distributors, and the like. Now, most recently here, earlier this year, OSHA extended the compliance dates associated with this rule. So there were compliance dates relative to, assessing the hazards according to these updated protocols, updating labels, updating safety data sheets, and the like. So again, this is another example of a gift of time relative to extending these compliance dates. Now, with this one, there are some things that might impact even just the users of chemicals and products. Also might impact some of our future Tier 2 reports as we see these new hazard categories potentially being identified for some of the chemicals we've historically used. So join us for next month's webinar. Our May webinar is going to be on this hazard communication standard. And what we're going to do in the May webinar is we're going to talk about the hazard communication standard, what has changed and what has not changed, so you can continue compliance with this standard relative to hazard communication and awareness for your employees. The next one is one that we've been watching for a while. So the heat injury and illness prevention in outdoor and indoor work setting rulemaking, that's a mouthful, was first proposed in 2024. This would be the first nationwide federal heat standard. As proposed, it would cover manufacturing, warehousing, agricultural, construction, and much more, even our postal workers, for example. And some states already have rules in place, but this would be our first nationwide heat standard. And again, this would apply to both indoor and outdoor work setting. And as currently written, there are two trigger thresholds. So when the heat index gets to 80 degrees Fahrenheit, there are actions that are prompted that require water, rest, shade, and monitoring of the employees. And when the heat index gets to 90, additional requirements kick in, including mandatory rest breaks, buddy system, and heightened supervision. The rule as proposed requires a written heat illness prevention program, and it also includes allowing your employees to acclimate to the heat. So on day one, they can't maybe work a full 8-hour shift outside. The acclimation process would be where we're exposing them to those heat indexes over longer periods of time, over a period of time for that acclimation to occur. It also includes training and record keeping requirements. So this proposed rule is not dead. It is still going through the process. So last summer, there was some public hearings associated with this rule. Last fall, the results of those public hearings were posted. So this one is still kind of slowly marching through the process of potentially being finalized. And more on this webinar, or excuse me, more on this topic. We did a webinar on this last year as well. So you can learn a little bit more about what's in this proposed rule and what it might mean for you as an employer that may have employees that are going to be exposed to these heat index levels. Now, our recommendation at this point in time is that we know heat is a hazard. And under the general duty clause, you have a responsibility to protect your employees from known hazards. So whether it's a proposed or a final rule, our recommendation is, because we know it's a hazard, develop a program, maybe in reference to this proposed standard, maybe not necessarily dotting every I and crossing every T relative to what's in this proposed standard, but using this proposed standard as a guide, as a best practice to implement written programs and protocols and policies to protect your employees from heat, both in indoor and outdoor spaces, because we know it's a hazard. And since we know it's a hazard, we do have the obligation to protect our employees from that hazard. And again, more information on those recommendations and this rule you can see in our archives webinar. This next rule was first proposed in 2025, and it is, again, proposed, not final yet. It is proposing to amend the medical evaluation requirements for the respiratory protection standard for just certain types of respirators. So essentially, as proposed, it would remove the medical evaluation criteria for employees required to use filtering face piece respirators, such as those dust masks or N95s, as well as loose fitting PAPRs. So currently, as the reg is written, if you require your employees to wear a dust mask or filtering face piece respirators, they must go through a medical evaluation. There are some voluntary protocols that don't require the medical evaluation, but if you are requiring your employees to wear them, then there's a medical evaluation element. Same with those loose fitting PAPRs as well. But if this rule is to be finalized, it will reduce that compliance burden for employers that require their employees to wear these specific types of respirators. Of course, this is raising concerns among occupational health and safety professionals about worker fitness and long-term exposure. It would require updates to your written programs if this goes through, if you are using respirators. So again, you would have to update your respiratory protection program and the implementation of that. But also this will impact some of OSHA's chemical specific programs that reference back to the respiratory program as well. So this is one that we're watching, just proposed at this point, but stay tuned as this one continues to go through the process. The next one that is just proposed, so just consider this an FYI at this point because it's just proposed. And this one was proposed earlier this week. And this proposed rule change affects the walking and working surfaces standard. And very specifically, this applies to fixed ladders that extend more than 24 feet above the lower level. Because as currently written within the walking and working surfaces program, those very specific fixed ladders must be equipped with personal fall arrest systems or a ladder safety system by a certain date. So what this proposed rule is proposing is the requirement to ensure that any new or replacement fixed ladders are equipped with the personal fall arrest system or ladder safety system would remain. That's unchanged. But instead, this requirement here in paragraph D that one would have to replace all existing fixed ladders, with those that have the personal fall arrest system and the ladder safety system by November of 2036. That's going away. And the logic behind this is the just the service life of fixed ladders. Um, it's kind of thought that these are going to get replaced before 2036 anyway, because new ladders are going to need to be installed because of end of life conditions. Replacement ladders are just going to happen as a nature of building maintenance. So with this proposed rule change, OSHA is essentially proposing that this final deadline is not needed just because of the replacement and maintenance of existing ladders will accommodate this need or this obligation. All right, so those are the environmental and the health and safety rules that we feel have broad application, maybe broad interest or broad appeal. From that federal perspective, some of which are final, some of which are just proposed. But those are the rules that we are watching. But wanted to kind of wrap up here with a couple of honorable mentions, and these might not have as much as a wide appeal, but definitely bear a conversation. And the first one has to do with greenhouse gas reporting rule. So earlier this year, EPA extended the deadline for greenhouse gas reporting rule for the 2025 reporting year, which was originally going to be due, that report was originally going to be due March the 31st of this year. But they've pushed that due date out to October 30th of this year. Now, if you've been keeping up with the greenhouse gas reporting rule, you'll know that the fate of this rule is uncertain, to say the least. This extension has to do with the rescission of the endangerment finding, which is the basis of regulating greenhouse gas. We could have a whole webinar on the endangerment finding and the rescission of the endangerment finding, but essentially that was the mechanism, if you will, for EPA to regulate greenhouse gases. So some speculate that the pushback of this due date for this report is just going to keep getting pushed until the rescission works its way through the courts and this rule eventually goes away. Now, the reason why we just kind of put this in the honorable mention is this rule doesn't apply to a large swath of our stakeholder groups. We only have a handful of clients that are currently subject to this rule, but it definitely bears honorable mention. So this rule, it applies to 41 categories of reporters based on the type of industry and the emissions. And so again, we don't see this one having broad applicability. But if it does apply to you, our recommendation is if this rule does apply to you and you are all set and ready to go for that March 31st deadline for reporting your 2025 greenhouse gas, go ahead and report. Or if you want to just have the benefit of time, make sure you have all the information ready to report. So that way, whether this rule goes away or whether the due date just keeps getting pushed back, you're going to have the information ready to go. This is just a pushing back of the due date. So you can go ahead and report and then you don't have to worry about it as well. Or you can play the time game and see if it just keeps getting pushed back. But if you want to play the time game, I just recommend make sure you know you have the information for the report already prepared and ready to go. Because if it just keeps getting pushed and keeps getting pushed and keeps getting pushed, and then eventually it doesn't go away, it stands. That way you don't have to go back in time to try to recreate the information for the report. You'll have it now when it's fresh in your head, fresh on the heels of 2025. Now, be aware that this is the federal greenhouse gas reporting rule. There are states that have greenhouse gas reporting rules. We might see some changes with some of those state rules, but I really doubt it. I think what we're going to see with this engagement finding rescission, I think we're going to see more action at the state level with greenhouse gas reporting. Currently, states such as California, Massachusetts, Washington, New York, Oregon are states that already have some degree of greenhouse gas reporting rule on the books. So just be aware of those state reporting obligations. Also be aware of your stakeholder reporting obligations. Maybe you don't have any federal or state rule that requires you to report greenhouse gases, but maybe you have a customer that has expectations built within contracts that require you to report your greenhouse gases or track your greenhouse gases or have reduction plans in place for your greenhouse gas. So, this the greenhouse gas rule, its fate is questionable. But what I would recommend is there very well could be other reasons for you to track and monitor and maintain greenhouse gas emissions outside of a regulatory framework, maybe more of a framework associated with customer and client expectations. So if you're maintaining greenhouse gas information, I would recommend continue to do that. Just the reason why you're maintaining it might just change over time. And the last one that bears honorable mention is the ISO 14001 standard. So ISO 14001 is the Environmental Management System standard. It is kind of the recognized global standard for environmental management systems. And it was just revised for a 2026 revision. The last revision before this one that was published earlier this month was 2015. So we've been operating under the same ISO standard for about 10 to 11 years now. And so with this new rule or this new revision, there are some updates to some standards, some clarification of some points, some additional obligations such as management of change, and some consideration of elevated environmental conditions. So if you are ISO 14001 certified, with this new standard being published earlier this month, you're going to have 3 years to transition your certification to this new standard. This just happened to be the topic of last month's webinar. So if you're interested in this topic, and if you missed last month's webinar, in just a few minutes, I'm going to tell you how to access our archives. And also, if you're interested, stay tuned because this summer we will be offering a day-and-a-half course. It's going to be offered remotely, so you don't have to travel to our offices or anything like that. We're going to offer a remote 1.5-day course that's really going to get into the details of the ISO 14001 standard, what's changed with this 2026 revision, what hasn't changed, and help prepare you to either establish or maintain an ISO 14001 environmental management system. So stay tuned for that registration coming soon, and check out our archives for last month's webinar where we got into a lot more detail of what the 2026 revised standard included. So with that, just a shout out to what we've got coming down the pipe relative to training. So we do offer typically 6 to 8 webinars a year, and so our next month's webinar, as I mentioned, is going to be on the hazard communication program, what's changed and what hasn't changed. So that registration is available on our website, whether you want to go to our website, hrpassociates.com/training, or you want to scan on that QR code. You'll see the information to go ahead and register for the May topic if that interests you. Even if you can't attend live, if you register, you will automatically get the recording sent to you. June, we're going to be offering in-person training at our Greenville office for hazardous waste RCRA and DOT hazardous materials training. July, we'll have another webinar topic to be announced soon. And then in August, that is when we're going to have that detailed 1.5-day ISO 14001 2026 standard training. Registration and information will be available for that in about a week or two. So stay tuned for that information. Our online training that we also have available at that hrpassociates.com/training website. Online training is available for you at any moment in time, according to your convenience. We have a myriad of topics, both on health and safety and environmental, as well as transportation, whether it's DOT, IATA, or IMDG. And then the archives. So as I promised, how to access HRP webinar archives. So we have a YouTube channel that is dedicated just to our webinar archives. So you can either scan the QR code to go straight to that webinar archives, or on YouTube, we are at HRP Associates Webinar Archive, and you'll see more information on some of these rules that we talked about today. More information on that TSCA PFAS reporting rule, more information on the TRI reporting and what it means to report PFAS chemicals as chemicals of special concern, more information on the methylene chloride, PCE and TCE rule, more information on that heat standard, more information on the ISO standard. So please feel free to access our webinars. It is complimentary for additional information based off of those interests in the topics that you have. So with that, I will take a look at our chat and our questions to see if we have any chat or questions that come through, but I'm going to leave it here on the screen. That is my contact information, both my phone and email. So if you have a question, but you just don't feel like typing it in, or you just don't, it's too long to type in, feel free to reach out to me directly and be happy to walk through your question. That's for whether you're listening to this recording or participating live. Feel free to reach out. All right, so let's see. I don't see any questions coming through quite yet. So with that, I won't hold you any longer than necessary. So with no questions or comments coming through, thank you for your time and attention. We hope to see you at the May webinar as we discuss that OSHA hazard communication rule and what's changed and what hasn't changed relative to your compliance with the OSHA hazard communication rule. So with that, thank you for your time and attendance, and we hope to see you at the next webinar.